she has those noise canceling headphones like yesterday.
That's who are you?
Kendrick, whenever you talk, you can't hear you.
Yes, ma'am, I can hear you.
Okay. Let's go on the record, please. This is cause number 2021 CR 8166. Harrington Kendrick. Attorneys, please make your announcements for the record.
Ana Ochoa Nelson for the state.
Gil Gonzalez for Carrington Kendrick.
Kendrick is appearing by video conference from the Bexar County Jail. Go. Ms. Kendrick, I can't hear you.
Yes, ma'am. Yes, Your Honor.
State your full name.
Carrington Kendrick.
We're here for the results of the TAP evaluation as well as the DDRF evaluation. Does either side want to be heard on those?
No, Your Honor, I've reviewed those. I've reviewed them with my client and our agreement of what was the information that was provided. And we believe that that is definitely a part of the plea agreement, not outside in any way.
Yeah, it recommends dual diagnosis outpatient, so that's what I'm going to do.
Okay. The only thing, Your Honor, that the concern that we have is that there's a request for no contact with the complainant. They do have children together, so we want to see if we can have a no harmful and injurious contact order instead of no contact.
State.
Judge, I don't believe we've had any recent contact with the victim in this case, so I do not have a recommendation from the state on that.
Yeah.
Just for the court's information, Your Honor, sorry. The children are 10 and 3.
Yeah, but that's the underlying issue with this case, that they were arguing about children and who was having them and who was not having them. So she is going to have to get that situated when she gets out. I can't. Is there a protective order on the civil side? Is there a custody order on the civil side?
None of that, Your Honor.
Yeah. If the victim is okay with it and they contact probation, I will immediately change it, but not without the victim first contacting them.
Understand, Your Honor.
Judge, I believe that in the PSI report, that probation's attempts to contact the complainant were also unsuccessful.
Yeah, but somehow magically, when I release people, those victims start calling. I'll leave it up to your client if to fix that part. Or she's either going to hire an attorney on the civil side to help her get access to her children, or the victim's going to call probation and we'll change it up. I do find that the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. I'm going to grant the application for deferred adjudication for a period of 5 years, $1,500 fine. The affirmative finding of a deadly weapon is held in abeyance. The state is going to dismiss 664127. I did check on that state. I don't have a dismissal for that. Restitution, if any, payable to Eric De La Rosa. An affirmative finding of family violence, 150 hours community service. As a condition of your probation, you will participate in the dual diagnosis outpatient treatment. For the first 90 days, I want her to report to a high-risk officer in person and make that a bi-weekly check-in. No contact order with Eric De La Rosa. This is a plea bargain case. I did follow your plea bargain agreement, Ms. Kendrick. You do not have a right to appeal. Do you understand?
Yes, Your Honor.
And Judge, I will do that motion to dismiss on the misdemeanor case right now.
Miss Kendrick, I need you to go into a breakout room. Information, please.
Yes, Your Honor. Thank you.
Yes, ma'am.
Your Honor, may I go in that room and then be excused from there?
Yes. You
you.
can explain to your client, Leo, the no contact situation.
Will do.
Miss Lippy, you need to join the breakout room. Your attorney's waiting for you.
Ashley,
Hold on. How do I do that exactly? I'm not too sure. There's no.
Down at the bottom where it says breakout rooms, if you click on it, it'll tell you.
Oh, wait.
room 10.
Join breakout room? Okay.
Bianca,
Thank you.
Bianca. Ashley, the trial court certification on Kendrick is not signed by defense counsel or the defendant. I need you to just circulate that one document, please.
Morning, Judge. It's Carl. How are you?
Hey, Carl.
Could Mr. Strange, myself, Gretchen, and probably Denise as well, all be put in a breakout room together?
Yeah. Go for it.
Thanks, Judge.
Linda, let me know when you're ready on Barnett.
On what, Judge?
Barnett.
Judge, can you do the PSI on Frazier next?
That's the one that's next, yeah.
Okay. Luis, are you back?
Yes, I am back.
Okay.
Thank you, Gretchen.
I'm going to go in my breakout room. Is that right, Ashley?
Carl wants to powwow with everyone. Tell him that that's the limit. He can't take two of my prosecutors at the same time.
I know I'm always a handful, Judge.
Pushing it, Carl. Okay, I'm ready on the Brandon Frazier.
Ashley, you want me to put me in 1-2, even though I have no idea what it's about?
Where, Adrian, I think this is yours, right? Yes, you ready?
Yes, Your Honor.
Okay,
Yes, Your Honor.
Dave, you ready?
State is ready, Your Honor.
Let's go on the record. This is cause number 2021 CR 8911 of the state of Texas versus Brandon Frazier. Attorneys, please make your announcements for the record.
Yes, Your Honor. Luis Echeverria for the state of Texas.
Adrian Pettis for the defendant.
For purposes of the record, Mr. Frazier is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name.
Brandon Frazier, Your Honor.
And the public application for probation.
Judge, I can't hear you with that guy.
Mr. Frazier, mute yourself. Mute yourself unless you're actively talking, please.
Hey, do you have any witnesses in opposition of the probation application?
For Brandon Frazier's case, Your Honor,
I'm Brandon.
we don't have any witnesses, Judge.
Okay.
Argument.
Mr. Bettis, do you have any witnesses?
Just argument, Your Honor. Actually, Judge, I'm sorry. I would like to call Mr. Frazier briefly.
Mr. Frazier, raise your right hand. Do you solemnly swear or affirm the testimony you're about to?
I do, Your Honor.
Go ahead.
Mr. Frazier, just mute and unmute yourself just like you did, okay? Throughout this process. We discussed your TAP evaluation and your pre-sentence investigation this morning. It looks like probation is recommended safe P if you're granted probation. Are you willing to attend safe P?
Yes, sir.
It looks like you have a substantial drug history, methamphetamine, cocaine, acid. It looks like you've been doing drugs for a long time and you've had a variety of drugs, correct?
Yes, sir.
Do you believe that you need treatment in order to kick the addiction?
Yes, sir.
Okay. With respect to your criminal history, it's lengthy, but it looks like all your cases have been state jail felonies or misdemeanors. Is that correct?
Yes, sir.
Do you understand that if you are granted probation in this case and you violate your probation and the judge thinks that you deserve it, you are facing up to 20 years in prison for this offense, correct?
Yes, sir. I understand.
You understand that if you're put on probation, there'll be rules you have to follow and the judge will expect you to follow each and every one, correct?
Yes, sir.
Do you have problems with complying with any reasonable requirement?
No, sir. No problem complying.
What are your employment plans when you get out of jail?
I have a couple of options. I got a guy named Fernando who owns a business called Metro Painting and Services, and then also there's I got a friend that he's worked at Red Lobster on I-35 in Waltham. He said he can give me a job in there as a dishwasher, and then another guy whose wife is a manager at the IHOP on 410 in Marbach. They can get me in as a dishwasher as well. So I have 3 options there.
Go ahead and mute yourself, sir. So you have 3 potential options for employment when you get out of jail is what I just heard. It looks like you're wearing a tan uniform. Are you a trustee at the jail?
Yes, sir. I work in the kitchen.
Okay. I'm assuming that you're a trustee because you've had no problems at the jail. Is that right?
That's correct, sir. No write-ups, no problems.
And how long have you been at the jail?
Since July 16th, last year.
So, not a mathematician, but about 8 months, give or take?
Yeah, about 7. It's a little over 7 months.
Where are you planning on living? The PSI report says that you plan on living at Haven for Hope. Is that correct?
Yes, sir. On the member side, they have a church and other things as well. They have counselors and everything that are there to help you succeed, get your stuff back together, get your life back together.
Do you know if you're going to qualify to be on the member side?
Oh, yes, sir. They actually have here where they can send you when they send I'm not sure exactly how it works, but they send information to Haven for Hope, letting you know that you're getting out of jail, and they have a program that automatically shoots you over to the member side.
I'll pass the witness.
Mr. Frazier, my name is Luis Echeverria. I am an assistant district attorney here with the Bexar County DA's office. I have a couple of questions for you, sir.
Yes, sir.
So you said you do seek treatment, is that right?
Yes, sir.
And you seek this treatment because of the extensive drug use that you had, is that correct?
Yes, sir. I'm ready for a change. It's time to become a man, really.
Okay, and this treatment that you say you seek, are you okay with having that treatment provided in a structured setting, like a placement setting where you're not free to leave the facility? Or what idea do you have about treatment?
Yes, that's fine. Whatever whatever y'all see fit for me to do. I've heard some real good things about this place called Lifetime Recovery. I've met a few people from there. I'm not sure exactly how that's set up, but I've heard some really good things, and it's real structured. But whatever, I'm pretty much placing my future in the judge's hands, because one thing I know, I haven't made the best decisions on my own. So I'm looking to start being obedient. That's pretty how I'm going to simplify my next 40 years of my life. Is I'm just going to start obeying, and therefore, because this is the result I've got from disobedience. So I'm just going to place my hands place my future in the lawyers and God's hands, and the judge's hands, and let them just start obeying. It's kind of like my 100% plan. So structured is great.
Okay, I have no further questions, Mr. Frazier. Thank you for your responses and your time.
Yes, sir. Thank you.
Anything else, Mr. Pettis?
No, Your Honor.
Argument?
Your Honor, if I may just briefly ask, so this was an opposed application, Judge? Is that correct?
10, yes, cap of 10 opposed.
Okay. Your Honor, the state's argument essentially is this. On this particular date, the offense that we know he's already pled to, there was a backpack. He was not initially in the vehicle when the backpack was in the vehicle, but what was found with him, he was riding on the passenger side of his vehicle. When he got into the passenger side of the vehicle at a Walmart and the officers approached for reasons related to the vehicle's traffic violations, they found him they found Mr. Frazier on the front passenger side, and that backpack that had been carried into the car by somebody else, by the driver, was now with Mr. Frazier, or between his legs anyway. What was found, Judge, were paraphernalia that suggests certainly that there was intent to deliver 50 grams of meth and roughly 7 grams, a little under 7 grams of cocaine. So certainly the 50 grams of meth, Judge, together with that cocaine, suggests that he was involved, certainly playing a role. He admits to not being employed and needing money, suggesting that he had a motive certainly for engaging in this possession with 4 to 200 grams intent to deliver. He has been sentenced twice. I know Mr. Bettis stated that he'd been sentenced twice or sometime prior on lesser felonies, Judge. These were 2 state jail felony cases, both involving possession under a gram, but was sentenced to 1 year in each of those cases. Had also been sentenced on a misdemeanor case prior, and a burglary of a building, also a state jail felony. He was sentenced to 9 months, Your Honor. So in light of the fact that he has been sentenced involving at least 2 different cases of possession under a gram, certainly the state's contention, Judge, is this is a much more serious crime. He was well aware of what he was doing. He certainly has an extensive drug history. And in light of that information, Judge, the state's argument is that he be sentenced to TDCJ, the institutional division. In the alternative, Your Honor, based on his testimony here this morning, if the court should deem it not in the state's best interest or in the court's judgment or in his own best interest to be sentenced to TDCJ, the state would argue that he go to safety as recommended both in the PSI and in the TAP evaluation, or at least the PSI references that that was the TAP's recommendation. That's the state's position, Your Honor.
Mr. Bettis?
Yes, Your Honor. I misspoke earlier when I was having Frazier testify, and I told him that he would be looking at 20 years if he violated. He's actually looking at 5 to 99 if he violates. I told him correctly at the time of the plea, but I misspoke today. I wanted to highlight on that, Judge, because, you know, this argument I'm about to make doesn't sound, it's not the best, but the way I look at it, Judge, is you have a client who you really have nothing to risk on. if he doesn't behave, he has that hammer over his head of 5 to 99 years of life. If that's not a motivator to do well on deferred adjudication, I don't know what is. Further, Mr. Frazier is a trustee at the jail where he's been about 7 months. That requires that he behaves, but moreover, it requires that he follows the rules. And that's what probation is, following the rules. He testified that he's going to have a place to live. He's already had 3 employment prospects lined up. And he's testified that he's ready to change and he's ready to give the drugs up. And frankly, I don't think he's ever had a real opportunity in order to kick the habit. His drug history is horrendous. That's not something that you could just wake up one day and decide you want to change. He needs help, and I ask that you give it to him, Judge. I don't think you have anything to lose. If he doesn't behave, he has that hammer over his head, and he knows that.
I do have to admit that I kept reviewing your PSI last night, thinking what a long history you have with drugs, only to find you've never been to treatment. And this has been going on for 16 years and never gone to treatment. 50 grams of meth is a lot. So that tells me you're not just hooked on the drugs, you're also dealing the drugs. So I think the level of addiction that you have is something that can appropriately be dealt with at SafeP. But this is going to be a conviction. It's not deferred. I'm going to grant regular probation. You're going to go to SafeP. I do find the evidence is sufficient to substantiate your guilt. I will find you guilty of the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams. I'm going to sentence you to 10 years confinement in the Texas Department of Criminal Justice. That is suspended. You're going to be placed on probation. In consideration of your plea, the state has dismissed 2021 CR 8910. I am going to order that you be transported to SafeP. You're going to participate in the program along with aftercare. When you're released from the halfway house, you're going to enter intensive supervision with the probation department. I want a job education training skills course, 200 hours of community service. I'm going to order a $1,000 fine. You're going to get to the business of being a law-abiding citizen, getting a regular job and taking care of your sobriety. We're going to do weekly UAs once he is released from the halfway house. If you abscond, if you decide this ain't working for you, whatever, you decide you don't want to do your probation terms, you already know your sentence, Mr. Frazier. It's 10 years. This is a plea bargain case. I did follow your plea bargain agreement. You do not have a right to appeal. Do you understand?
Yes, Your Honor, thank you.
And for purposes of the record, I did previously sign the dismissal, so he shouldn't have any other holds. I need you to go into a breakout room with probation, please, Mr. Frazier.
Yes, Your Honor.
Patricia Esquivel, are we ready on that PSI, or what are we doing on that one, Ashley?
Esquivel is at 1:30 and David Garcia is requesting a reset on that.
So for this morning, I just have Barnett, and when is Isaac Gonzalez this afternoon?
Judge, we're here on Isaac Gonzalez right now.
Sorry, Mr. Miller. You're right. You're here. Okay, I have that, and I have the plea for Adrian, Adrian's client, and then we'll be ready for Barnett. Any updates on Conway?
They're all in a breakout room still.
And Judge, on Mr. Banks, it looks like it may have to be, I've just got back for the second time with Mr. Lyles. It's looking like a hearing at some point down the road, contested. Just letting you know.
It was contested before you came on.
Oh, okay.
Yeah, so I fully expect it to be contested. I'm ready to give him a contested hearing. You want your 20 days?
Well, I'd like to, if there is a new felony, and so I'd like to have a little time to review that. I don't have, I didn't expect it to be right away. I thought maybe just a few days. I don't need 20. Maybe a week or less than that, just so I can know what's going on with the.
Either a new felony.
Yeah. It's alleged. That's, and Mr. Lyles is going to send me some stuff on it, so I'm in good shape there. It's,
So on the assault family choking, he's on for 5 over 5, and then there's a new assault family choking.
yes, Your Honor, it's alleged.
Okay.
And
It's alleged. I'm trying to find a place where I can park you and give you the hearing. State, how much time do you need to prove up the MTR?
Judge, it shouldn't take that long. We'll have a victim and probably 1 or 2 officers, and then the probation officer.
Okay, so then let's do a Friday. What does Friday, March 25th look like? David, look at your calendar, please. Objections? Okay, March 25th.
Thank you. May I be returned for a moment to the breakout room with Mr. Banks, please?
Let's do that at 9:30.
Mr. Davidson, you signed all my documents.
Thank you.
Can somebody put Jaheim Conaway in breakout room with Mr. Strange and Mr. Alexander?
Thank you, Gretchen.
What is Linda back?
She was taking a plea in the 175th.
Okay. And has Mr. Sanchez, is he wanting to speak with anyone on Trevino?
Are they talking for Sanchez? Sanchez. He's still talking to his client in the back conference room.
Okay.
Let's go on the record on Isaac Gonzalez, please. State, whoever's handling Isaac Gonzalez, I don't have dismissals, and there's quite a few. There's 4 dismissals coming.
Yes, Judge, I'll get on those right now.
Okay, let's go on the record, please. This is cause number 2021 CR 1824, the state of Texas versus Isaac Gonzalez. Attorneys, please make your announcements for the record.
Family laws for the state, Your Honor.
Anthony Miller for Mr. Gonzalez. Your Honor.
Okay, Mr. Gonzalez is appearing by video conference in the Bexar County Jail. Where is he?
He may be in breakout room 8, Judge. I'm not positive of that, but.
Yep, yeah. On Faustino Trevino, I'm resetting it for March 31st. Mr. Sanchez needs time to gather some medical information. All right, Isaac Gonzalez is back. Let's go back on the record. Mr. Gonzalez, you have to unmute yourself. He needs to sign a reset. Mr. Gonzalez, unmute yourself, please. There you go, right there. Leave it like that. Go ahead and tell me your full name for the record, Mr. Gonzalez.
Isaac Gonzalez.
All right, we're here for the results of the PSI, the TAP, and the DDRF. Does either side want to be heard on those results?
Judge, we have nothing to add to those documents.
I'm sorry, you guys were talking at the same time. Mr. Miller?
Judge, we have nothing additional to add to the documentation that has been provided to the court.
Okay, I'm ready to proceed. I did accept your plea of no contest to count 2 of the indictment. Mr. Gonzalez.
Yes, ma'am.
You remember that?
Yes, ma'am.
Count 2 is an assault family second offense. I did find the evidence was sufficient to substantiate your guilt. I'm not going to make any other findings. I'm going to grant the application for deferred adjudication for a period of 4 years. $1,000 fine. The state is going to dismiss 2021 CR 4414, 2020 CR 4413. You might want to check me on that, Mr. Lyles. 2021 CR 4657 and 2021 CR 4640. I think
It's 4413. I apologize if it's incorrect in the paperwork, but I have sent the dismissals already.
on the 4413, it's 2020 or 2021?
2021.
Thank you. So that's for purposes of the record, that's the case that's getting dismissed. I'm going to order the Batterers Intervention Prevention Program, no harmful or injurious contact with Jennifer Miranda, 200 hours of community service. I'm going to have you evaluated for gang supervision. He doesn't qualify. I want him in intensive supervision. This is a plea bargain case. I did follow your plea bargain agreement. You do not have a right to appeal. Do you understand, Mr. Gonzalez?
Yes, ma'am.
You're going to go in a breakout room with my probation. They're going to give you your conditions. If you have no other holds, you should be released.
Yes, ma'am. Thank you.
Judge, if I could just advise the court, I believe that $1,000 fine was to be probated, Your Honor, if I'm not mistaken.
That's correct, Judge.
For purposes of the record, the $1,000 fine is probated. You're absolutely right. I wrote that down.
Yes, ma'am.
Thank you.
Thank you.
We have the clerks come get their stuff. Mr. Bettis, let's do your plea next.
Judge, may I be excused at this time, Your Honor?
Yes, sir. Thank you, Mr. Miller.
Thank you very much, Your Honor. I appreciate the court's time.
Brandon, did you need paperwork or have an announcement?
Just an announcement whenever the judge is ready.
I can hear you. I can multitask.
On Aaron Elias, we just wanted to remain on trial docket, Judge. We're close, but we want to keep the case moving forward.
Is it a family violence case?
It is not, Your Honor. I was with Luis Echeverria.
Put it on the CTD call docket for the first week of April, Ashley.
Is he interested in a court trial, Brandon?
No, he's interested in a jury trial.
Okay, what about a hybrid jury trial? I can knock that one out in a week and a half. We have jurors.
I don't think I know what a hybrid jury trial.
I can send you the consent. Basically, we pick the jury on Zoom and then we do the trial in person.
Okay, I would have to talk to my client about it.
Can you ask him before I give you the date, please?
We're both in 6, Brandon.
Okay, thank you.
Get ready to go on the record on Joshua Baca. Give me just a few minutes, okay? Let me, no, let me take care of them first. Give me just a quick minute. I'm pulling up the paperwork for Joshua Baca. Is he sworn in?
Yes, Judge.
Hey, Gretchen. You're on mute. That thing we talked about, we're good.
Okay, let me, Judge, are you available?
In 2 minutes, I'm signing a warrant.
Thank you, Judge.
Yes, ma'am. Gretchen.
Judge, so I think that we are going to be able to work out the Conway case, but we have not been able to reach out and talk to the victim on that case. And I think that we need to do that before we finalize the case. So
Okay.
we could get added onto the docket next week because what I think we're ultimately going to agree on is going to include DDRF. And so they want him to get on the waiting list as quickly as possible. If we do have an agreement, I just don't want to do it without talking to the victim first. So can we put it on for next week for a plea?
I don't know about next week.
Yeah, 16th is stacked, Judge.
Yeah, because I put a bunch of stuff on the 16th. Can we do? March 3rd. Is the arrangement or the agreement that you guys are looking at include disposition of the 3 pending cases?
Yes.
We'll wrap up everything across the board,
Right.
Judge.
And we would just use the current evaluations on the criminal mischief?
Yeah.
Yes.
I'm fine with that. So let's do March 3rd.
Judge, if I might, I had filed a motion to withdraw. I would like to just table that because if we can come to a resolution into that, I'm all for that. I thought this was going to be a situation where they were just going to go forward with 2 aggravated robberies, which was just going to be, and I'm basically pro bono. And so I would like to just table everything because I think we're going to work this out.
Sure. Okay, no problem. I haven't, I'll make sure that those are still, there's still attorney of record.
Thank you, Judge.
Thank you. All right, we'll see you guys March 3rd. Thank you.
Thank you, Judge.
Does Brandon have an answer on the hybrid trial situation?
Brandon,
Yes, Judge. I consulted my client. He wants to keep with a traditional trial. I apologize.
Okay, so is this, no, it's CTD, right?
Yes.
Yes, Your Honor.
Or
Judge, it's my case.
I know I'm starting you up that first week of April, but 4/6, yeah, 4/6.
Thank you, Judge.
Thank you.
Is Linda back yet?
Yes, I am ready to go on Barnett, and Judge, I'd like to request a reset on Pablo Saldana. I'm having some problems getting everything done this morning.
Fine, I'm gonna do Mr. Bettis's client first on Joshua,
Yes, ma'am.
and then we're gonna do Barnett.
Yes, ma'am.
Can you do next week on Saldana? In fact, I have, who's next week? Judge Parker? Judge Parker will be next Thursday.
Let me just look at my calendar, Judge. I'm really packed on Thursday, Judge. I could do it on the 15th or the 16th.
Judge, not the 16th, any Thursday this month, really.
Okay, let me just look at my next Thursday.
The 17th or 24th.
Well, it seems like everybody's doing things on Thursday. I could do the March 3rd, Judge, if we do it at 9 a.m.
Judge, this is a situation where I think the defendant needs to appear in person.
I would agree, Judge.
Okay. Where is Mr. Saldana? Mr. Saldana, I need you to appear in person in my courtroom on March 3rd for the MTR.
Judge, may I appear on Zoom?
Yeah.
And Gretchen, I'm going to be reaching out to you.
Okay.
You understand, Mr. Saldana? Go ahead and unmute yourself and tell me you understand.
You need to hit your mute button to unmute.
Okay, yeah, I'm writing it down right now, ma'am. March 3rd?
March 3rd, 9:30. Thank you.
9:30?
Thank
Okay,
you, Judge. I'm sorry we couldn't get this done today.
That's okay. We have enough time to just do one plea and.
Okay. I'm ready on Mr. Barnett whenever you are, Judge, as well.
Okay. Let's go on the record on Baca, though. Mr. Davidson, what do you have? Oh,
I have Mary Lippy.
okay. Do you want to come back at 1:30 or you want to wait for? I have an opposed PSI with at least two more witnesses that I can tell argument. So after this plea, it's that PSI. Do you want to do your plea, wait till after that, or you want to come back at 1:30? 1:30, a lot of things fell off, so it's actually, I could do you first at 1:30.
That would work well, Judge.
Okay, we'll see you guys at 1:30 then.
Thank you.
Send you the link for the 1:30 docket.
Okay, thank you, Judge. I'm gonna go ahead and get off and come back on at 1:30.
Is that Denise? What is she doing?
Yeah, she's crazy.
Yeah. I just gotta be off. I just gotta be off about 2:15 so I can see the baby.
No problem.
Okay, thank you.
Are we
Bye.
Judge, am I allowed to leave?
Yes, ma'am. Come back at 1:30.
Okay, yes, ma'am. Thank you.
Let's go on the record, please. This is number 2021 CR 9759, the state of Texas versus Joshua Baca. Attorneys, please make your announcements for the record.
Samuel Laws for the state, Your Honor.
Adrian Pettis for the defendant.
Mr. Baca is appearing by video conference. Go ahead and tell me your full name, sir. You're going to have to unmute yourself.
Joshua Baca. Your Honor.
Okay, Mr. Baca, on the screen, I have the true bill of indictment that was filed in this case. It alleges the offense of aggravated assault with a deadly weapon. Do you understand the charge that you have this morning?
Yes, Your Honor.
And state, are we proceeding as charged?
Yes, Your Honor.
That is a second-degree felony, Mr. Baca. A second-degree felony is punishable by confinement in the Texas Department of Criminal Justice, the Institutional Division, for any period between 2 and 20 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes, Your Honor.
You have the right to a jury trial. You have the right to cross-examine the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, Your Honor.
When you sign the document that I have on the screen called the court admonishments and defendant's waivers, what you're telling me is you want to give up those rights. Is that what you intend to do today?
Yes, Your Honor.
Is this your electronic signature on the screen above the words Joshua Baca?
Yes, Your Honor.
Are you a citizen of the United States?
Yes.
If you are not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Baca, are you satisfied with the representation of your attorney?
Yes, Your Honor.
Mr. Pettis, does your client have a rational and factual understanding of the proceedings against him?
Yes, Your Honor.
Has he been able to assist you in the preparation of any defenses?
Yes, Your Honor.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, Your Honor.
I will accept the waiver of rights and make it part of the record. Mr. Baca, let's go over this plea bargain agreement. Just to be clear, State, is this a recommendation?
Yes, Judge, it's a recommendation for deferred. I apologize.
Mr. Baca, on the screen, I have the plea bargain agreement that you made in this case. It is a recommendation of 10 years deferred adjudication, $1,000 fine, no harmful or injurious contact with Katie Garcia.
That's correct, Your Honor.
We're going to do a DDRF evaluation. I see that there's a rush there, but I don't know that there is a way to rush it.
Judge, I just put that as if we can do it as soon as possible and probably while he's still in custody, just to be safe.
Okay. TAP evaluation, affirmative finding of family violence by agreement, and the affirmative finding of deadly weapon is held in abeyance. 200 hours community service. Is that your understanding of the agreement, Mr. Baca?
Yes, Your Honor.
Mr. Pettis?
Yes, Your Honor.
Mr. Lyles?
Yes, Your Honor.
What is your plea to the charge of aggravated assault with a deadly weapon? Is it guilty, not guilty, or no contest?
Guilty, Your Honor.
Are you entering a plea of guilty because you are guilty and for no other reason?
Yes, Your Honor.
Has anyone forced you to enter a plea today
No.
or offered you anything in exchange for your plea?
No, Your Honor.
I will accept the plea of guilty. I find the plea is voluntarily made, and I will ask the state to tender its proof.
State offer 6 Exhibit 1 along with attachments.
Any objections?
No objections, Your Honor. No, Your Honor.
State's one is admitted. Mr. Pettis, are you satisfied the state complied with Article 3914?
Yes, Your Honor.
I will sign the discovery acknowledgement and make it part of the record.
Judge Bianca did chat us that it was March 7th is the earliest DDRF evaluation in custody.
Yeah, let me read the facts and then I'll make a decision on that, okay? Give me just a minute.
This is Linda Corley. I don't know if I missed my name.
Linda, we're in the middle of a plea.
I'm sorry.
Okay, let's go back on the record. I have read the facts and I'm not going to delay the DDRF. I'm going to have Mr. Baca evaluate it while he's in custody. You've been there this whole time. With these set of facts, I'm not going to release you without having some sort of idea or structure for you, okay? So March 7th will be your first evaluation. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings at this time. So Mr. Baca, what I need you to do is go into the breakout room with probation. She's going to set you up. You need to talk to him, right? Yeah, she's going to set you up with that evaluation March 7th, okay? And then let's do a PSI and a DDRF and a TAP. So March 7th is his first evaluation. Let's set him for March 24th. Anything else before we go off the record?
Nothing from the state, Judge.
Thank you, guys. We'll see you.
You, Judge.
Thank you, Your Honor.
Thank you, Adrian. What date did I give you, Linda, on Saldana?
3-3.
3-3.
Okay.
9:30.
All right, let's get ready to go on the record on Barnett.
Judge, we have quite a few people in the waiting room. Do you want to let them in or?
I mean, they're not my witnesses. What are they here for?
Shonda had testified at his hearing, and it's his mom, and she just wanted to be here to see the finish of the hearing. That's the only one I'm really concerned about.
My victims are here, Judge. My victim, and then I think his sister is also logged on. She will not be testifying. It'll just be the victim.
I mean, I to me, it doesn't matter. This is your hearing. So you could just let them all in. It's fine. Now let's go on the record, please. This is cause number 2021 CR 1526 and 2021 CR 6523, the state of Texas versus James Barnett. Attorneys, please make your announcements for the record.
Gretchen Slater for the state.
Linda Corley for defense.
Barnett is appearing by video conference from the Bexar County Jail. Mr. Barnett, unmute yourself and please tell me your full name.
James Sean Barnett Jr.
Okay. You're here for the results of the DDRF evaluation. This is an opposed application. Give me just a quick second. Okay, we're here for the results of the DDRF evaluation, the TAP evaluation and the PSI. We had already taken testimony from multiple witnesses the last time that we were here in court. And I understand that the attorneys want to reopen the
Yes,
testimony. Okay, state, call your first witness. I'm gonna, go ahead.
State calls Garrett Woolard.
All right, see. Oh, okay. Mom, is he over 18? Miss Woolard? No?
You're muted.
No, ma'am, he's not.
Okay. So if you don't mind just moving over so he's in front of the camera, because I can't see him right now. Okay, so Mr. Woolard, Garrett, I need you to raise your right hand. Do you solemnly swear or affirm the testimony that you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Go ahead, state.
Would you spell your name for the record?
Garra.
Hang on, you're frozen.
Who's
Oh, you unfroze. Can you start again?
GarrhettWoolard.
And how old are you?
I am 17.
And what do you do? Do you go to school?
Yes, ma'am.
And who do you live with?
I live with my mom.
And where do you live? Just the part of town.
Shirts.
I'm sorry?
Shirts, Texas.
Okay. I want to just go straight to February 25th of 2021. Do you remember that day?
Yes, ma'am.
Can you give the judge a brief summary about what you recall happening that day?
I was going to my car and he came behind me and pulled me aside and punched me in the face. Then he tied my hands up, brought me to some other apartment, and he put something over my head and continued to hit me.
What kind of injuries did you sustain from what he did to you?
I have a fracture on my nose.
Did you have to go to the hospital for that?
Yes, please. Yes.
And were they able to fix that fracture?
I don't think so.
And can you tell the judge about the physical pain that you suffered?
It was just, I was scared and I was hurt.
Did you know this guy?
No.
Did you assault him in any way?
No, ma'am.
And can you tell the judge how what happened to you that day has affected you?
It made me scared and afraid for my life, and
do you have any nightmares?
a few. That was about it.
Do you have difficulty sleeping at all?
Yeah.
Are you going to any kind of psychiatrist or any counseling for what happened to you?
Yes, ma'am.
Okay. And is that helping at all?
Somewhat.
Okay. Were you afraid to appear to testify before this judge?
Yes, ma'am.
And why?
I was nervous and scared.
Okay. I pass the witness.
No questions, Your Honor.
Is there anything else that you want to tell me, Mr. Willard? I saw the pictures. I've read the reports. I've read everything in this case.
Not that I can think of. I don't have anything else.
Okay. Well, thank you for being here today. Any other witnesses?
I would like to call his mother, Scarlett.
She testified the last time. Is there something different?
Oh, nope. Sorry, I cannot recall what happened last time. I'm sorry, Judge.
All right. She testified the last time.
Okay.
I took very good notes.
Okay. I trust that, Judge. And that would be all that the state has.
Defense, call your first witness.
Your Honor, I don't have any additional new testimony for you.
Okay. Argument.
Waive my right to open, reserve my right to close.
Thank you, Judge. May I proceed?
Please.
Judge, we understand that these cases are extremely serious. No one is doubting that. I think I would just like to, and I know that court took wonderful notes. It's been a while, but we did have testimony of all of the times that my client's family has tried to get him help. They do believe strongly he needs mental health help. He needs to get a good diagnosis. I believe he had a previous diagnosis, but we do think that he needs to be reevaluated, and we would like to have the court give him an opportunity to get the help that he has not been able to get on so many occasions. Our client's mom has tried getting mental health warrants to have him evaluated, tried to get him mental health on various occasions, got him into some hospitalization, and that was it was unclear. There was no continued help from that location. So what the family is praying for, Judge, is that you will allow him to get in programs to get him the help that he needs, so he will be long-term, be able to be in the community, be safe, and be the person that he can be if he has the right help with that, whether that's just mental health or it's drug treatment. He did have a referral for the mental health program, and the family is not asking that you release him, Judge. The family understands and would like for him, that he needs to stay in custody, and that there are programs that would be in custody for some length of time before he would even be allowed to start on probation if the court gives him that opportunity. That's what they're praying for, Judge. They're not praying that he be released. He is not asking that. He understands that he'll have to be in custody. We're asking for the court to step in and be able to provide what the system has failed to provide so far, although the family has reached out and attempted to use the system to get the help that they needed for Mr. Barnett, for their family. And if we just throw him away, as it's so easy to do, then he won't get that help. And he'll just be put in prison, and then he'll be paroled out, and he won't get any of the help that he so desperately needs. The system has failed him so many times. So we are requesting that the court allow him to stay in custody while he gets that help before allowing him to be released on any deferred or straight probation, as the court would agree to do. Just to reiterate, we're begging the court not to just throw him away into prison. We're asking for the system to not fail him one more time, and to allow him to get the help he so desperately needs.
Judge, I think it's, he's a 24-year-old man. This isn't some child that has never been given a chance. He had family support. They tried to get him help, but you know what? He has to want that help. And I have seen or heard nothing that indicates that he wants that. In his PSI, he minimizes everything that he did. He won't take responsibility for his choices, for his decisions. And you now have two victims that will forever be impacted on the decisions that he made. This 17-year-old boy, I can't imagine what he was thinking, how he was feeling, and how this will forever affect him. I'm sure he has PTSD from this incident, and this defendant should be punished for the choices that he made. Yet again, I want to reiterate, he is not a child. He is a 24-year-old man who made choices, and he should suffer the consequences of those choices. I don't believe that it is correct to say throw someone away by sending them to prison. Sending someone to prison is giving them consequences to the choices that they made. There are resources in prison to help with mental health issues, to help with controlled substance issues, if he so chooses to take advantage of those. And that is the appropriate place for someone who has greatly affected several lives by the choices that he has made, the violent choices that he has made.
I have reviewed this case probably a whole lot more than any other case that I've had, because it is unique in its own way. There's a lot of different things that happen, and I broke it down, Mr. Barnett. So, and for Mom, I see Mom is on Zoom, and I see Mom teary-eyed. I understand. I gave this case so much consideration. and you're getting a lot of cases dismissed. I am assuming that those cases involve your own family, assaults against your own family circle. And had that been the case for me, this would have been a different situation. But I have 2 victims, not within your family circle, one girl you were dating, and then I have this young man that has absolutely nothing to do with your family. He is lives in Bexar County, drives in Bexar County, goes to school in Bexar County, just like all of us do. And I cannot, in good faith, grant deferred or probation in this case. This is not a probation case. I look at all the times you were arrested and released, and I 100% believe your mom that she has tried her best to get you help. But you are almost 25. You'll be 25 in a few days. So there's been, from the time that your mom had any say in it until now, at least 6 or 7 years, where as an adult, you should have gotten the help that you needed for your mental health, if that's what was happening. What I didn't see in the PSI, what I didn't see in any of the testimony is what were you doing every time you got released? Not taking care of business. So it is not the system's fault. It is not this court's fault. You didn't take care of business the times that you were released, because you were released right away every time you were booked and didn't do anything to take care of business for your mental health, if that's what was going on. If you had told me, I went to the Center for Healthcare Services after I assaulted my grandfather or my grandmother or my sister, and I couldn't finish that program out. Nothing like that in this case. And you did, in fact, minimize what your actions were. You did. You minimized it in the PSI. So that tells me it's someone who knew exactly what he was doing. I grant on ugly, awful cases deferred all the time to send people to treatment, all the time. But in this case, in good faith, I cannot. So that's my decision. I'm not granting probation. In cause number 2021 CR 1526, that's the ag assault deadly weapon. I do find the evidence is sufficient to substantiate your guilt, and I will find you guilty of that offense. I will sentence you to 8 years confinement in the Texas Department of Criminal Justice. Institutional division, you do get credit for the time that you have served. There is an affirmative finding that a deadly weapon was used in the commission of this crime. This will run concurrent with 2021 CR 6534. The state is going to take into consideration a lot of cases. State, I don't have any dismissals for that. I need those tendered, please. There is also an affirmative finding of family violence. There is to be no harmful or injurious contact with Jan Barnett, Shonda Barnett, and Kiara Waits. And I apologize, no contact with Kiara Waits. This is a plea bargain case. I did follow your plea bargain agreement, Mr. Barnett. You do not have a right to appeal. In cause number 2021 CR 6534, that's the aggravated kidnapping. I do find the evidence is sufficient to substantiate your guilt. I find you guilty of that offense, and I will sentence you to 8 years confinement in the Texas Department of Criminal Justice, the institutional division. You do get credit for the time you have been in custody. There is also an affirmative finding. There's no affirmative findings in this case. This will run concurrent with 2021 CR 1526. State, you might want to check me on that. I don't believe there's any findings in this case. This is a 3G case, no matter, regardless of the findings. So this is also a plea bargain case. I did follow your plea bargain agreement. You do not have a right to appeal. Is there anything further from either side? Is there any victim impact?
I do not believe so. Did you want to do a victim impact?
No? No victim impact? Ms. Woolard,
you're muted. Ms. Woolard. Did you all want to do a victim impact?
I'm not sure what that is.
Okay. So it's your chance to tell the defendant what you want him to know. The judge has sentenced him to prison. So it's if you choose to tell him what you want him to know.
Yeah.
Go ahead.
Yes, ma'am. I just kind of want to thank you. First of all, I just want to piggyback on what you said. And I believe, this is a grown man, and the crimes, the things that were done to me in his mind, I'm thinking, and I don't know if this is the right thing to say. I mean, it's almost like in your mind, maybe you thought you were an assassin, just the things that you did, the things that were played out. That's not normalcy for someone, a grown man, to do. And, I think a lot of people went, trying to prove the innocence, bringing the grandfather up and asking the grandfather, what did you do many, many years ago that has nothing to do with you? And if you need that help, there are those avenues in prison or in jail. And that's something that you need to do. That's something that if you don't want to be in the prison population, because there's always somebody that's a little meaner or angrier than you think you are, then that would be the avenue that you could use to get out and get help. And that's all I have to say.
Thank you. All right, we're going to go off the record. Ms. Corley, if you need to talk to your client and the family, you can go in a breakout room. State,
Judge, I have 4 cases that need to be dismissed. Is that accurate?
I have 4 felonies, 3 misdemeanors.
Okay, I have 2020 CR 7980.
Yes.
I have 2021 CR 7038.
Yes.
I have 637667. I have 664806. That's all I've got.
Yeah, I think you're right. Yes, because the other 2 are the ones he pled to. Okay.
Okay. I'm on it.
Thank you.
Judge, I'll have to call his family and visit him in jail. I have to be in another court.
Yes, ma'am.